Well, I'm Peter Coy. I'm the economics editor at Bloomberg Businessweek magazine, and I'll be your guide and host for the next hour and a half. We have a fantastic session lined up. Don't go anywhere. You're going to be hearing from three law professors in the following order: Patricia Mccoy from Boston College, Kathryn Judge from Columbia, and Michael Greenberger from University of Maryland. And all three of them are highly knowledgeable in the field of financial regulation. And they're going to be talking about this in a way that fits right into the framework of this two-day conference. So we'll be looking at things in a little bit of a Minsky perspective. And I want to set the stage with my own little story from yesterday, a personal story. My niece, I have a niece who's a law student, actually, quite left in her politics, do-gooder, concerned about prison reform and sentencing and so on. And she has never cared a whit about capitalism, but she was watching Dogecoin go up. And it went up 10,000% just since the start of 2021. So she emailed my son, who works for a hedge fund, and said, should I be putting my money into Dogecoin? I have $200. Is that a good thing for me to do with my money? And that crystallized for me that we are in a bubble. And so I would call it, I would like to ask the panelists, in addition to the comments they have already prepared, where they think we are in terms of bubbleiciousness in the US economy. Have we reached the Ponzi stage of finance? Anyway, with that as a preface, I'm going to introduce the panelists with their bios one by one. And we're going to start with Patricia Mccoy, who is the Liberty Mutual Insurance Professor at Boston College Law School. She, in 2010, 2011, was appointed the first Assistant Director of Mortgage Markets at the then new Consumer Financial Protection Bureau. She's also served on the Consumer Advisory Council of the Federal Reserve Board and the Advisory Council on Economic Inclusion of the FDIC, currently sits on the Federal Reserve's Insurance Policy Advisory Council. She has 3 books to her credit, including The Subprime Virus, which was came out in 2011, was written with Kathleen Engel. So Elizabeth Dunn is going to be at the controls of the slides. And with that, I would like to one other thing I want to say before I turn it over is that we're going to have the panelists speak for 20 minutes each. I may be interrupting here and there on behalf of the audience when there's something I think needs some clarification or elaboration. And then we'll have abundant time for interchange among the panelists and with the audience. So you can start firing questions. Please use the Q&A box, not the chat box. And I will try to get in as many questions as possible. So with that, over to you, Professor Mccoy.
Great. Peter, thank you so much. And Dimitri, thank you for your kind invitation. I'm not seeing my slides up yet. I didn't know if they could be queued up. There we go. I'm going to talk today about something I've been concerned about for quite some time, which is the disintegration in its implementation of the system for non-bank systemic risk regulation that was set up in the Dodd-Frank Act. And we can move to the next slide. Thank you. Just as a very quick recap, the Dodd-Frank Act created the Financial Stability Oversight Council, FSOC, and it authorized FSOC to oversee systemic risk in 2 major ways that I will talk about today. The first I call entity-based regulation, and the second is activities-based regulation. Next slide, please. The entity-based approach, I think most of the audience knows, designates individual firms as systemically risky. And I want to just look at the statutory standard because it will be important for our conversation. Congress authorized FSOC to designate a particular non-bank financial firm as a systemically important financial institution, or a SIFI, if one or both of the following standards applies. Either material financial distress at the company could, not would, could pose a threat to U.S. financial stability, or that the nature, and I won't read the other words, you can read them, et cetera, of the company's activities, again, could pose a systemic threat. Any company that FSOC designates as a non-bank SIFI then undergoes enhanced prudential regulation and systemic risk supervision by the Federal Reserve Board. The Federal Reserve, as part of that, has substantial enforcement powers as well. Next slide, please. The other activity, the other power of FSOC is activities-based regulation. This is very different from entity-based because it singles out individual business activities for systemic regulation, either across an entire industry or at least across a segment of an industry. And we do see examples elsewhere in Dodd-Frank of activities-based regulation, derivatives regulation. I'll talk about it in a second, that FSOC helped instigate money market mutual fund rules. So these are examples. But the thing that's really important to understand about activities-based regulation is that FSOC can only recommend it. It cannot require activities-based regulation, and it cannot issue those rules on its own. It can only recommend to, let's say, an agency like the SEC adopting an activities-based rule. In contrast, entities-based regulation is mandatory. When FSOC votes for designation, then it will happen. All right, so entity-based regulation is the stronger power under Dodd-Frank. Next slide, please. So what's the track record? Dodd-Frank was passed in 2010. It went into effect in 2011. And what we saw under the Obama administration was an initial wave of designations. Specifically, FSOC designated 4 non-bank companies, 3 of which were the insurers AIG, MetLife, and Prudential, and then finally GE Capital, as non-bank SIFIs in the early years, in 2013 and 2014. And all 4 of those companies then underwent systemic risk supervision by the Federal Reserve. Now, this did not mean that there was no criticism. Au contraire, there was quite a lot of criticism. First of all, the insurance industry argued that it was not prone to systemic risk. But in addition, one of the easy targets of an entity-based approach is that it can create an unlevel competitive playing field. And there was further insurance criticism that insurance companies and bank-centric Federal Reserve regulation do not mix well. Next slide, please.
Professor Mccoy, can I just ask you to evaluate those 2 arguments of those insurance companies? I mean, you said what they thought, but do you think they were correct or wrong?
Right, exactly. I think that the larger argument that the insurance industry is not prone to systemic risk is wrong. AIG was an example of that, and of course, with AIG, the derivatives danger was actually in a non-insurance affiliate. However, the securities lending activities of the insurance subsidiaries themselves contributed to the failure of AIG. And so we can directly see that there was systemic risk emanating out of the insurance subsidiaries themselves. I will say that large life insurers seem to be more likely, more susceptible to systemic risk than property and casualty insurers. The other problem with that argument is that the largest insurers are huge conglomerates with no serious consolidated oversight at the parent company level. We don't have serious consolidated oversight at the state government level, and we don't have it at the federal level. And so what that means is insurance companies can buy savings and loan companies, they can buy banks, they can buy shadow banks, all of which themselves can generate systemic risk.
Thanks.
Great. So what happened under the Trump administration? I like to say that entity-based regulation suffered death by 3 cuts. Okay, first, FSOC de-designated GE Capital and Prudential. Actually, the Obama FSOC had already de-designated AIG. Meanwhile, MetLife went to court to challenge its SIFI designation, and it won in the district court, after which the Trump administration, FSOC, did not appeal that decision. So long story short, today there are no non-bank SIFIs left standing in the US. Second, FSOC, under Chairman Steven Mnuchin, adopted a guidance establishing such a high standard of proof that SIFI designations today are almost impossible to vote in and withstand court challenge under the MetLife decision. And here, I would criticize FSOC in this guidance for coming up with a new standard saying that there could only be designation if the company in question would pose systemic risk, not could, but would. That is in derogation of the statutory language of Dodd-Frank. And so I think there are very good reasons to reverse this guidance. And then finally, FSOC under Mnuchin announced that it was substituting activities-based regulation for entity-based regulation. And it just wouldn't use entity-based regulation at all. Next slide, please. Now, how about the track record of activities-based regulation? Under the Obama administration, we only saw one activity-based regulation adopted, and this was a hard-won fight that took several years. But in 2014, FSOC finally convinced the Securities and Exchange Commission to adopt a rule that changed the pricing practices of institutional prime money market mutual funds. There have been no other activities-based rules to date. And that's no surprise since FSOC lacks the power to mandate them. I will say that after the Mnuchin FSOC embraced activities-based regulation and said that's really the only thing we'll pursue, then it didn't even recommend anymore. So I think that that was really just giving lip service to activities-based regulation. It wasn't a serious embrace.
Okay, can I just ask another question here?
You bet.
Hypothetically speaking, if you had good activities-based regulation, not the kind that Mnuchin had, but good, would that be sufficient? Why do you need entities-based as well if you do activities-based?
I think the biggest reason why you also need activities-based regulation.
Or also need entity-based.
Excuse me. Yes,
yeah.
Thank you. The biggest reason is that in a very, very large shadow bank conglomerate, you can have interaction effects between what one subsidiary is doing and another that activities-based regulation alone cannot capture, because activities-based regulation is just looking at one activity. It's not looking at the interaction effects. So I think that's the principal reason why we still need the power. A second reason is that we do worry about the solvency risk of entities, of shadow banks, and entity-based regulation can give an X-ray into exactly what's happening with the solvency or lack thereof of a particular entity. That is really important. And the last thing I'll say, this is a fault of Dodd-Frank, but unless FSOC can threaten entity-based regulation, then it's really hard for it to exert pressure for activities-based regulation.
Makes sense.
Next slide, please. And how am I doing time-wise, Peter?
Well, I didn't measure exactly when you started, but 5 minutes, I'd say.
Right, okay. So in sum, entity-based regulation was effectively dismantled under the Trump FSOC. Activities-based regulation is all that's practically left, but the FSOC lacks the power to require it. That's why I think non-bank systemic risk regulation is on life support. And that problem has been, has fallen under the radar screen. Next slide, please. So now we have a new FSOC chair. Where does she come out? And I think it's hard to read the tea leaves. Previously, Chair Yellen filed a very important comment letter opposing the Mnuchin era guidance, in which she vigorously defended the importance of entity-based regulation and said that FSOC should never should never put that on the back burner. More recently, there was a well-publicized exchange between Senator Elizabeth Warren and Chair Yellen at a Senate Banking Committee hearing in March, in which Yellen sent mixed messages. She was asked by Senator Warren, would she favor designating asset managers, including BlackRock? And she answered that question no, that she preferred to pursue activities-based regulation. But then in the ensuing Q&A, she also said that it is appropriate to designate institutions whose failure would pose material risk to US financial stability. So we're just going to have to see how this story unfolds. And last slide, please. What will it take for FSOC to be reinvigorated under Chair Yellen? I think the most important thing that FSOC needs to do is to reverse the Mnuchin era guidance. It has plenty of authority to do this. And this would preserve the ability to designate when necessary in the future. The other thing that I failed to mention, but I want to mention here, was that FSOC's budget and its staff were slashed in the last administration, and FSOC badly needs to have staffing and budget reinstated. Finally, there is an action item for Congress. I think the chance of this being enacted is low, but Congress really needs to amend Dodd-Frank to give FSOC the power to mandate activities-based regulation. So with that, Peter, let me wrap up, and I welcome any thoughts and questions. Thank you.
Great. Well, thank you so much. We're going to have a more thorough Q&A later on, but I want to ask you two questions right now, just off of your talk. One is, to what degree does the MetLife decision constrain what FSOC can do?
So it constrains it in two major ways. One is that it took that old statutory language from Dodd-Frank, allowing designation if a company could threaten financial stability, and strengthened that to only if it would. That's a much harder thing to prove. The second thing is that the MetLife District Court essentially told FSOC that it's going to have to use much stronger statistical tests to show that a particular non-bank company poses a systemic threat. And my analysis is that in many cases, FSOC will not have the data in order to muster this higher standard of mathematical proof. And I think you've alluded, Mr. Kaplan in the prior session alluded to big data gaps. So I think this higher statistical test is a real problem.
Great. And the other question, just before we move on to the other two panelists, is about Yellen's remarks in March, and referring to BlackRock, because one way to interpret what she said is that she was really only referring to BlackRock and asset managers, which you could say are maybe not as systemic because they're not leveraged. They don't have as many ways to cause trouble as, you know, AIG did, for example. And so that you could parse her words fairly narrowly. That's all she was saying. What do you think about that?
I think that's a possible interpretation. And to put a gloss on that, she also expressed interest, and I would say a commitment to first doing further studies of the asset management industry. She is very thorough in insisting that systemic risks actually be identified before then deciding what regulatory tool to use. So maybe that's what she was saying. Maybe she was saying it's premature. However, when I played that clip over and over, she didn't quite hedge it that way. It seemed to be a definitive, no, we're not going to designate BlackRock. I have to say, as a former regulator, I never would have made such a definitive yes or no commitment. I was a little surprised at that. Okay. The other thing I will say is we've seen from past designations that the primary concerns seem to be with life insurers, putting aside GE Capital. And so to your point, she may feel that other industries are more urgent in terms of thinking about designation than asset management.
Okay, well, very good. We'll come back to you later. For now, we're going to move on to our second panelist. Kathryn Judge is the Harvey J. Goldschmid Professor of Law at Columbia Law School. She's an expert on financial markets, financial regulation, regulatory architecture. She's an editor of the Journal of Financial Regulation, a research member of the European Corporate Governance Institute, and a member of the Financial Stability Task Force, sponsored by the Brookings Institution and Chicago Booth School. Before joining Columbia, she clerked for Judge Richard Posner of the Seventh Circuit Court of Appeals and Justice Stephen Breyer of the Supreme Court. And with that, over to you. Professor Judge, thank you very much.
All right. Well, thank you for having me. And thank you to the organizers. This has already been a great day and a half of conferences. It's always a pleasure to follow Pat. I've missed seeing her in person. And I think my core comments, which I'm going to get to later, really follow on the themes that she was raising. And I think one of the things where there is a lot of agreement coming out of last March is 2007, 2008 revealed massive shortcomings in both our regulation of banks and our regulation of non-bank financial intermediation. We've made significant steps forward in our regulation of banks. So we need to stay diligent, but we've made a lot of improvement. When we look at non-bank financial intermediation, we still have a long ways to go. And so I think it's both understanding entity-based and activities-based regulation as complements, and Pat's work with, Jeremy Kress and Dan Schwartz does that beautifully, but it's also looking at the regulatory architecture. I mean, a lot of the fragilities that we saw in March were ones that were well known well before March and yet hadn't been addressed. So I do think we need to think a lot more critically about how do we put the infrastructure in place at a regulatory level. So when we both can identify threats, it scares me when Robert Kaplan is sitting there saying, yeah, well, we kind of look at banks and we know what's going on in banks, but we also know the non-bank financial system is a huge part of how we do financial intermediation. And there's a lot I just don't know about what's going on in that domain. So clearly, I think we need to rethink that area. But before we get there, by virtue of Kaplan being one of the speakers and Charles Evans yesterday, I also wanted to take a few minutes to talk about the regional Fed banks, because I feel like they tend to get a hard rap. And I would like us to actually have a more vigorous conversation about the role that they're playing, and perhaps even put them in a slightly more positive light than they've received so far. So as you noted, it's a panel of legal academics. Legal scholars like to think that they are experts in administrative law. There's an entire field of administrative law that's all about how do we go about designating from these established branches of the executive and Congress a huge amount of authority to these regulators that are not actually elected. And in that scheme, most of the focus traditionally was on the confirmation process, appointment and confirmation. It's been on a removal by the president. This is how we get accountability to the president. More recent efforts have said we need a richer account of accountability. And so they've added things to the picture like, well, how accountable are you to Congress through budgeting and those types of processes? And when you look at the regional Fed banks through that lens, they look incredibly problematic. So more charitable accounts have looked at them as a vestige of history. More critical accounts, colleagues that I respect, like Peter Cotton-Brown, has said, you know what, they really look unconstitutional to me under the court's recent jurisprudence. They are very often seen as mechanisms of capture. It's like they're supposed to oversee banks, and suddenly we have a third of the board members as banks. They're required to be representatives of banks in that area. So they are often seen in a very critical lens. Yet I think that they are both incredibly important and particularly important right now. I just was looking really quickly. So we had Evans yesterday. So first of all, he brings a long-term perspective. We like to think that central banks with these 14-year terms that people at the Fed, the Board of Governors are supposed to have this long-term perspective. There's nobody who's sitting on the board right now who was there during the last crisis. Evans was. He's been serving since 2007. You go to their website, and part of what they are actually creating, you see that they do these wonderful quarterly ag letters. So you're getting really detailed information about commodities prices, about animal husbandry, about kind of credit access for farmers. And then the senior economist there who creates these letters does a little YouTube video every quarter saying here's what's going on in this space. They've had a bunch of great virtual events about kind of access to capital in Detroit for Detroit's minority-owned businesses, looking at housing stability in Detroit. And again, these are issues that are fond of me. I grew up in Southeast Michigan, so I care a lot about Detroit's well-being. I have relatives who farm, so I care a lot about those issues. But I'm skeptical that those are issues that we would see the board otherwise looking at quite as closely. Similarly, today, we saw Kaplan talk about how much engagement he engages in, how much during the past year where we've had incredible tumult, he's increased that engagement. Similarly, when you look at their website, we see a huge number of really important activities that he's been engaged in. They have a Southwest Economy podcast. So they're really looking in a very local way, what's going on in this area. We heard him talk about education and making sure that people are getting the skills that we need. We've seen a lot out of the Minneapolis Fed recently. So Neil Kashkari has obviously been quite outspoken and was a known figure long before he took the helm there. But they've been promoting events on racial disparities. They did, I think, a remarkable job recently where they actually expanded what they put into the Beige Book. And so the Beige Book is, again, traditionally a key mechanism through which we get all these different regional insights into the materials that not only are the Fed members looking at, but other people are looking at to try to understand, well, what's going on in the economy. And so he, of his own, or the bank, I don't want to attribute it just to the leader, but of their own volition, they added new sections on worker experience and minority and women-owned business enterprises. So what we're really seeing here, I would say, are things that suggest to me just the opposite of the concern that these reduce legitimacy. I do think we have to think about governance and potentially think more rigorously about governance. We might want to think a little more about the locations. I mean, I don't know if we still need 2 in Missouri, and I don't know if the overall western half of the country is as well served as it could be. On the other hand, what we're seeing first is they are really engaged in their communities. And that's critical both because it allows them to bring a different set of insights and perspectives to those conversations when the FOMC meets, but it also plays a role going in the opposite direction. And again, legal scholars tend to think about elections as being the mechanism through which you get engagement outside the Beltway, but we see them regularly not only hosting virtual events, but attending all kinds of events. And they're a voice of trying to explain, here's what we're about and here's what we're trying to achieve. And I think that is also a critical role for legitimacy.
Can I just jump in for a second? You're focusing on the regional bank's role in sort of the economy, but the regulatory side, which is our focus here, is really more done out of the Federal Reserve Board in Washington, right?
It is, though it's actually carried out by the regional banks. I mean, I think that they're the ones that are carrying out oversight. When we look at last March or 2008, when the Fed had to create a whole variety of programs under 13.3, it was the regional Fed banks that were creating those programs. So if we're looking at Main Street, it was the Boston Fed. And again, there's engagement, but it's the Boston Fed that's implementing those programs. But I think part of the key is we're thinking overall about both the regulatory side, and I do want to get there, but also the monetary side. I want to suggest we need to think about this as a system, and where there's not only the input going in, but there's also the information flowing down. And this gets to I think where you're heading. So there's the legal debate, and I'm saying I think it's way too narrow. But there's the second debate. And another strange thing about academia is there's the legal academics who think that they know all about administrative law. And then there's all the economists who also talk about central bank independence. And so we have a whole literature on CBI that actually doesn't speak that much to the legal academics. And there, the way they have tended to talk about legitimacy is we have to create time-consistent policies, we have to stay in our lane, we have to be clear with what we're about. So we're hearing all these concerns recently about central bank activism and are they being too activist? We saw, even in 2007 and 8, when there was a meaningful expansion in what the Fed was willing to do through its lender of last resort tools, a real effort to still frame it as if it's time consistent. It's budget. I mean, Bernanke was like, it's budget. We have banks, we have non-banks. So all we're doing is budget for non-bank financial intermediation. So it's still this very clear effort to say, look, we're doing exactly what we know we're doing. I think right now we are instead in a period of both change and contestation. So COVID itself was a massive shock. COVID both revealed and accentuated massive disparities in the economy. And I think we've seen all of the regional Fed, many of the regional Fed banks, but also Powell really speaking to those disparities. There's all these concerns about climate change as potentially a new type of threat. And that's, and again, this gets into the financial regulatory over what's activism to deal with, or what is like putting your head in the ground and actually not living up to your responsibilities. And so I want to get to the conversation about non-bank financial mediation, but I think what I really want to push here is what we're seeing right now at the Fed. And I think Powell embodies this, but the regional Fed banks are a critical portion of this, is when you have a model that actually captures what you're trying to achieve, there's a lot to be said for making that model known and then adhering to what you're supposed to do. But there's going to be periods of contestation and change where the models you have just aren't going to work, and where there's real questions over what it is you're trying to achieve and how best to achieve it. And during those periods, part of what's interesting is Powell hasn't tried to pretend that he's just kind of like doing the same old thing. Instead, he's taken an approach of like, well, we need to engage and we need to talk about what we're trying to achieve and talk about what we're worried about, and even talk about the things that we don't yet know, that where the uncertainty lies and how we're monitoring those areas of uncertainty. And so I think when we're going through this particular period of change and contestation, that the regional Fed banks play an even more critical role, and things like expanding what goes into the beige book is part of that. So it might not seem like financial regulation, but it is part of the institutional architecture that I think is really key for both understanding for monetary policy, but also for financial regulation, what the priorities need to be and how we want to go about achieving that. And so there's a broader debate I would love to see had about the structure of the overall Federal Reserve System. I mean, I think too often, journalists like yourself, every Fed journalist knows that, like, if you want a nice juicy quote that doesn't completely toe the line, the easiest thing to do is to call a Fed regional bank president. So they're kind of, but I actually think that's a positive. I mean, I think it might drive DC crazy, but for me, that's what creates the internal contestation. And so if we're not going to have elections be the critical mechanism, and they're not going to serve and removability is not going to be the mechanism through which we get accountability, what are the ways you can create a regulatory design that actually allows for divergence and discussion internal to it?
Yeah, just one last thing about that, since you teed it up, it's hard to resist. The surprising thing is how much unanimity there has been at the FOMC, which includes both the governors in Washington and the presidents of the regional banks, to the point where some people are saying there's groupthink and we've lost that diversity. And I know that's a monetary policy question, which is a little bit off, but I thought you might have a thought about it.
Yeah, no, I think it's a great question. And I actually think it's a recognition that during difficult times, there's something to be said for the appearance of unanimity. And I think all institutions that are not constituted of elected officials, recognizing that there's some fragility around the margins in their legitimacy in the eyes of the public. As you mentioned, I'll say at the beginning, I was a Breyer clerk. The year I clerked for Breyer was the year that Justice O'Connor announced her retirement, and then Chief Justice Rehnquist passed away. So we had 2 new justices joining after a long period where there hadn't been any change. Mm-hmm. And I'll be honest, you look at the decisions from that term, and they are at times decided on potentially more narrow grounds to achieve a greater level of consensus, which doesn't mean over time the contestation didn't return. It clearly did, as we all well know. But there is a settling process. And I do think that there's seems to be a consensus that I respect, and I don't think it's meant to last forever, that we are dealing with such an important shock, and that is so significantly crippled, significant swaths of the economy. And we're looking at working mothers, we're looking at the racial implications and how heartbreaking those are. And there needs to be, precisely because we know that there's going to be a lot of naysayers, some, not uniform voice, but some broad consensus in what we're saying. So I think it's not going to be the same in 2 or 3 years, but I actually think I really respect it under the circumstances. All right, so just go ahead.
I'm sorry for slowing you down, because I know you have a lot you still want to cover, so please go ahead.
Yeah, no, and I'll keep my other comments brief because we have a lot of things to conversation. Yeah. But I just want to go back to what Pat was saying. I mean, we really are in a world where there's always the need to be diligent with respect to the large, complex banking organizations, but we've continued to have a huge part of our financial system operate outside of the direct prudential overview of regulators. It's outside the banking system. It's a bunch of disaggregated entities that collectively engage in similar financial intermediation. And we saw so many fragilities there in March. And I think one of the dangers is because the Fed came in aggressively, but also Congress came in really aggressively and kept coming in, which were both, I think, very positive developments on the whole. There were a lot of fragilities that we were right on the verge of really erupting that managed to be contained by virtue of the fact that there was such broad support, both in terms of liquidity provisioning and more accommodative monetary policy, but also just such incredible fiscal support that we really saw the economy through. But that does not mean that there were not a lot of near misses that still require a lot of attention. And I think they've been well cataloged. I mean, I think the Treasury market dysfunction in March is something we all know we really need to look at. The money market mutual fund runs, the runs on other open-end mutual funds that were backed by illiquid assets, the margining, by CCPs when they were making kind of demands on clearing members and really sucking liquidity out of the financial system. So what we saw were there a lot of things where we managed to avoid disaster, but I'd say we were closer than we ought to have been.
Sure, yeah.
And so I think what that has to tell us is, first, we obviously need to create this catalog and just go through and address all of those areas. But second, and just as importantly, we need to make sure we have a regulatory scheme that actually is better suited to identifying potential threats to stability and trying to address them in a more timely way. And as I think Pat nicely laid out, Dodd-Frank tried to achieve this, right?
Yes.
We have a famously fragmented regulatory system. We have 3 bank regulators, 2 market regulators, housing finance. So we have this, and one idea is we should really consolidate and restructure. There's a lot to be said on that. We've never managed to make meaningful progress. The other is we're going to create this council, bring everybody together, focus them on, financial stability in that context, and create this OFR, this Office of Financial Research, to try to promote the creation of all the data that President Kathryn was saying he desperately wants, and I think he really ought to have access to. And we just haven't seen that work the way we want it to. So just a couple of comments. I mean, on the entity-based front, since Pat teed it up this way, they created 2 buckets, right? So there's a bucket for SIFIs, the systemically important financial institutions, that right now sits empty. I think, like her, it's part because the lower court decision in MetLife was wrongly decided, and partly because that was abandoned, and partly, but I think there might be more to that. I look at the exchange, and then we also had the financial market utility. So let me just also say that. So we actually do have 8 designations. So it might look like it's worked better, but some of the CCPs that are sitting in there actually, looking at some of the margin calls that they imposed on some of their members, I don't know if they are actually subject to appropriate prudential oversight right now. I mean, the CFTC just wasn't designed to be a prudential regulator in quite the same way. So part of what happened is we created these 2 buckets. One currently sits empty, the other is full, but despite the fact that they've been designated, it's not clear that they're being regulated in a way that actually addresses the threats to stability that they pose. So I do think that there's at least the possibility, and this goes to your point about BlackRock, of thinking maybe rather than just saying you have to fall in one of these 2 buckets, one which is kind of motivated by what we do for banks, and the other which doesn't really ask that much of you, we need to have a separate process where you can look at kind of all the, the largest asset managers and say, first of all, what are the potential threats to stability that they pose, and how best to address those? And maybe it's putting them in one of the buckets, but maybe it's going to Congress and saying, look, we need to do something else, or maybe it's going to the primary regulators. And similarly, I think the primary regulators also are going to continue to play a key role. So the way we get activities-based regulation, as Pat nicely laid out, is the FSOC trying to tell the primary regulators that they need to address something. But I feel like it's got to be more iterative than that. Because first of all, the FSOC is made up of all those primary regulators, right? And so they might not want to tell, colleagues what to do if they don't want to be in position of being told what to do, which might be why we only saw it being used once and not even all the way there, and only for a threat that actually became manifest, the money market mutual funds, as opposed to some of these other areas that also potentially pose threats. So I think we need to re-examine whether or not sitting on the FSOC is enough, or do they also need to have more of a mandate to promote stability and resilience, and also the office and the staff to really support that. And again, I think Pat made the really nice point looking at the OFR, looking at FSOC, but also for me, looking at the FSOC members. We're not going to be able to address this unless they are all staffed up in a way where they really have people on it who understand resilience and who understand interactions. I mean, part of what was interesting is we saw the bank regulators doing one thing, the market regulators doing other things. Each of them were taking actions that had very meaningful impact on the other domain with incredibly little engagement, coordination, or consideration of those collateral consequences. So I guess the big picture is just we have I think there's the ability to make progress, but also a need for progress and a long way to go when it comes to creating a regulatory structure that can help us to better address threats before they can become manifest. Thank you.
Thank you. Just a question on that last point. The FSOC, of course, was created under Dodd-Frank, and the whole concept of it was rather than disband or merge the individual primary regulators, there would be this council where they could come together and make sure that there were no gaps, for example. And conceptually, kind of makes sense. Each regulator does what it's best at, the CFTC, the SEC, OCC, and so on. And then but then they coordinate with each other. And similar to the way you were saying there's a virtue in the regional Federal Reserve Bank presidents coming in each with his or her own view to Washington to talk about things. So I take your point certainly about the lack of financing for the OFR and things like that. And maybe the lack of empowerment of the FSOC that it can't order activities-based regulation. I take that point, but at least conceptually, do you think it makes more sense to have this sort of a framework, the FSOC up here and then primary regulators down here, rather than a single unified regulatory body that kind of does everything?
Yeah, I mean, I think there's virtues to both approaches, but I think there's a lot to be said for the current approach. So it's really not trying to challenge the blueprint that Dodd-Frank created, but Dodd-Frank was trying to do something incredibly ambitious, and there wasn't a good model out there. You know, there's a bunch, like I said, there's a bunch of academic literature on all these issues. Another one is on specifically what should regulatory structure look like for purposes of effective financial regulation, single regulator or Twin Peaks, and we have these various models out there. The US has never fit any of them, so FSOC didn't fit any of them. And I think my key is this was a conceptually good first step, but it hasn't been as rigorous or robust as we wanted to. And what are the additional things that we need to do in terms of creating both the incentives and the competence at each of those different member regulators? So they're showing up at that meeting saying, here's what I'm seeing in my domain. Or, you know, when the bank regulators are undertaking changes to liquidity regulation, they're thinking, well, what is this going to do in terms of the consequences in other domains for liquidity and liquidity provision? When the SEC is undertaking changes for money market mutual funds, trying to figure out, like, where is this money going to go if there's a demand for short-term and safe assets? And it's that ability and really encouragement to really work collectively that we just haven't seen. And I think, again, your point about the OFR, partly, you know, we need more funding there, but partly they need the support of the other primary regulators. And we haven't seen that, I think, be as rigorous as we really need it to be for that infrastructure to work. So I think there's a bunch of incremental changes that we could make that collectively could make that overall system more effective.
So Professor Mccoy was talking about Yellen's presentation in March, and saying it's hard to read the tea leaves and what kind of a leader of the FSOC she will be. I'd just like to ask you the same question. Feel free to disagree with your predecessor on this or agree, but how do you see Yellen running the FSOC?
Yeah, so a couple of comments on that. I think she's going to be hopefully the strongest leader of the FSOC we've seen so far. And that was another point of contestation, is who should actually lead this? Should it be the Ministry of Finance, you know, the Treasury Secretary who's a member of the President's cabinet, or somebody else? And I think she's probably more committed to these issues than any of the Treasury Secretaries we've had since we've created it. I mean, she was very vocal last summer while she was still at Brookings in talking about how critical it is that we do a better job with non-bank financial intermediation. So I think she's doing a great job in that sense. On the other hand, she's got a very full agenda. And so part of the question, and this is why I really wanted to reiterate Pat's comments about the staffing of the FSOC. For this to work, you need a robust staff, because the Treasury Secretary is always going to have a very full agenda that is constantly monitoring and following up on these issues, and that is providing an incredible amount of support. So I think she's, you know, as good as we've seen so far, and I'm very hopeful that she will make meaningful progress. But I think time will tell, but I also think she could use some more tools that she might not currently have.
Okay. Well, good. We will come back to these issues, but for now, I want to move on to our third panelist. Michael Greenberger is a law school professor at the University of Maryland, Francis King Carey School of Law, where he teaches a seminar entitled Futures, Options, and Derivatives. He was actively involved with members of Congress in the passage of Dodd-Frank and in oversight proceedings concerning the implementation of that statute. Professor Greenberger was previously the director of the Division of Trading Markets at the CFTC, the Commodity Futures Trading Commission, where he served under Chair Brooksley Bourne. And that was quite a time. In that capacity, he supervised exchange-traded futures and derivatives. And I'm breezing through people's biographies. You can read more on the website. But I don't want to take too much time with the intro, so I'd like to move on to Professor Greenberger. The floor is yours.
Thank you, Peter. I also want to thank Dimitri, Han, Randall. As usual, the Minsky conference this year has been exceptional and not at all hindered by us having to deal with it remotely, although I'll be happy when we can see each other in person. The greatest form of flattery I can give you is while I was waiting to come on, I got an email from a former student who's now a very successful asset manager who said he's very worried that we're in a bubble. What did I think? And I said, what I think is pretty irrelevant, but if you want the best guidance you can get the recordings of this conference. I truly, sincerely believe that this has been as close as you can come to getting a good feel for where we're heading and what our problems are going to be. President Kaplan talked about things are happening and he didn't know how they would dealt with because they can't be seen. And I think in that regard, there's been a lot of talk about non-bank intermediation, non-bank involvement in financial markets, and that they are not as well regulated as banks are regulated. I would just say that for purposes of trading derivatives, and Citi, JP Morgan, Goldman, and Bank of America are counterparties in 90% of United States originated derivatives, they are only seen not through their prudential regulation, but through their regulation as swaps participants, formally designated under Dodd-Frank and regulated so that they have enough capital to be in the business, collateral, that swaps are cleared, and therefore twice a day, margins are called for losses on your side of the portfolio. These requirements came from Dodd-Frank. Dodd-Frank was a reaction to the 2008-2009 financial collapse. I will provide citations to a very detailed article I wrote on both the issue of swaps and how I fear that the US regulators had lost control of the sight that Dodd-Frank was supposed to give them into these transactions. Gary Gensler was the chair of the CFTC after Dodd-Frank passed. Frankly, I think the strength of Dodd-Frank and its requirements that swaps be regulated, both ensuring adequate capital participants, adequate collateral, transparency, and clearing. A lot of that had to do with Gary Gensler's position as being the chair of the CFTC while Dodd-Frank was being promulgated. His job after Dodd-Frank was promulgated was to implement somewhere in the neighborhood of 60 rules that were required by Dodd-Frank to be made formal in order for the provisions of Dodd-Frank to go into effect. And my law school professor colleagues have talked about administrative procedures. I can assure you that getting 60 rules through what the Administrative Procedure Act requires is nothing short of a heroic feat. At the very end of that process, after those rules had been fully published, in July of 2013, the CFTC did what it thought was its last job, which was to make clear how Dodd-Frank would apply to foreign transactions that fit within the swaps framework. And essentially, the requirement was very aggressive in that you could not, if you were a US bank, for example, evade Dodd-Frank by trading through foreign subsidiaries. And the reason for that was going all the way back to 1992, when the swaps market was first started. The International Swaps Derivatives Association, which is the private regulatory system that swaps dealers operate under, the very first thing they did was to tell the world that if you deal with a foreign subsidiary of a US bank holding company, you are effectively dealing with the US bank. And the reason for that is that by the derivative boilerplate, the holding companies, the bank holding companies, guaranteed the financial status of their foreign subsidiaries. And that is written and was written into every contract from 1992 to 2014. In the guidance for foreign application of swaps, it was an 80-page guidance, triple space, far too complicated, but there was over 600 footnotes. And footnote 593 said, if a foreign subsidiary is guaranteed by a US bank holding company, it will be regulated under Dodd-Frank, because that's all there was at the time. US foreign subsidiaries of US bank holding companies were, by virtue of swaps contracts, guaranteed. 1 month later, under cover of darkness, the International Swaps Derivatives Association issued to its swaps members a directive to change the boilerplate in their swaps agreements, the ones that exist and the ones going forward, to de-guarantee all subsidiaries. Because in this footnote, the CFTC said a guaranteed subsidiary is controlled by Dodd-Frank. So we'll get out of Dodd-Frank by de-guaranteeing our foreign subsidiaries. And as I said, under cover of darkness, the CFTC, which regulates 95% of swaps, was never told about this. But in the spring of 2014, and by the way, in December of 2013, Gary Gensler had left his chair of the CFTC. In the spring of 2014, the data collector started to notice that the number of US swaps was dwindling dramatically. And the question went out as to why this was happening. And, excuse me, after several months of investigation, it was discovered that they were dwindling because the US bank holding companies were moving their swaps from the Wall Street facility to London, Japan, Berlin, what have you, and saying these are no longer US swaps. But the story is worse because the banks gave themselves the benefit that if the swap was negotiated by US personnel on Wall Street and then assigned to a foreign subsidiary, it was not a US swap. So they had the best of both worlds, control over creating the swaps, finding the customers, but then taking the position that the swaps were not regulated by Dodd-Frank. There were no collateral requirements, no capital requirements, and the margin requirements were much, much reduced, not twice a day under a formal swaps clearing apparatus. By May of 2016, the CFTC, as a regulatory matter, figured out what was happening and started in its regulatory format, rule by rule, saying you can't avoid this, this regulation by assigning the swap to a foreign subsidiary. And then in September 2016, they promulgated an informal rule that abolished the whole concept that somehow you can avoid Dodd-Frank if you're a big US trader in swaps. And the four big US banks at that time were counterparties and 90% of all swaps originated in the United States, you could not evade Dodd-Frank.
Professor Greenberger, can I jump in for a second?
Sure.
This is a fascinating story, and it's a really important one. There's a lot of detail here. The basic bottom line is that swaps dealers were evading regulation by loophole by going overseas. You said something just a minute ago about an informal rule. Did I hear that correctly? What is an informal?
It was a proposed, I didn't use the proper administrative language. A proposed rule was issued in, early in May of 2016, followed in September, where the Obama CFTC said, this is crazy, you can't get out of Dodd-Frank. Trump comes into office unexpectedly. As you would expect, that rule was never finalized. And even worse, not only was it never finalized, but even after the 2020 presidential election, the Trump CFTC promulgated its own formal rule embedding what ISDA had done through its rearrangement of its contracts. So now there is a formal rule that even if you negotiate your swap in the United States, and by the way, we're talking about $150 trillion in notional value of swaps. The US swaps market is 300. The best guess is that half the swaps that were normally being deemed US swaps are now deemed foreign swaps and not regulated by Dodd-Frank. Right. And let me quickly add, the regulation in the foreign countries is nowhere near as rigorous as the regulation under Dodd-Frank. So you have this huge market that is now, as President Kaplan tells us, unseen. We don't know what's happening. These are the very instruments that caused the 2008-2009 financial crisis. If you go to today's Wall Street Journal, there are 2 or 3 articles about the recent financial instability in the market because of the GameStop situation, Archegos, what have you. And in each of those articles, there is discussion at the heart of all these matters are something called total return swaps. And indeed, in today's Wall Street Journal, Gary Gensler, who is now the chair of the SEC, is saying that total return swaps, that is in effect the way you get assets, equity assets, without owning equities. You derive the value of those equities through a total return swap. And these swaps are in jeopardy and collapsing. As Archegos had very serious problems, up to $10 billion in its instability using these kinds of swaps. Some of these swaps may be legitimately foreign swaps, but many of them should be regulated under Dodd-Frank, should be transparent to US regulators, should be transparent to FSOC, should be transparent to the CFTC, should have capital requirements, collateral requirements, margin collected twice a day. I'm sure margin goes off for months and months where they're never being called when the market is going well. And as Hyman Minsky said in his financial instability hypothesis, when markets are going well, that's when speculation takes off. And that's when we hit a Minsky moment. The Dodd-Frank regulation of $300 trillion notional value of derivatives by making them transparent, capital supported, collateral supported, cleared, twice a day margin was intended to cabin the discretion that leads to the financial instability hypothesis and the Minsky moments. Those requirements are gone. The final point I would make is, if you read about what the Biden administration is going to do with financial regulation, We've talked about Janet Yellen. By the way, I've worked with Janet Yellen. I think she is absolutely phenomenal and will be terrific. She may have had a few false starts, but by the end, she will be a dynamic leader. We now have Gary Gensler at the SEC. There has been no mention by the Biden administration of who will lead the CFTC under President Biden. And that clearly, whoever takes that job, their number one priority will be to go back to September 2016, when they were calling into question the self-developed exception to Dodd-Frank, and to resuscitate the work that was being done then, and to undo the damage that the Trump presidency has done to swaps regulation. There are two very strong Democratic commissioners at the CFTC now. One of them was Gary Gensler's general counsel. Both of them have stood shoulder to shoulder in opposing the Trump deregulatory posture. So who ends up with that job will be critically important. There's no doubt in my mind that one of the first things they will do is to return to the Obama CFTC skepticism about having swaps negotiated, arranged on Wall Street by Wall Street employees, United States employees, but then by the simple assignment to a foreign subsidiary being deemed outside of the therapy that Dodd-Frank provides for transparency and financial stability.
Thank you very much. I love the way you picked one issue and went deep on it, because sometimes that's what you need to do. It's really instructive. So are you pretty optimistic then that this rule will be changed?
Yes, I'm optimistic. I would love to know who the next chair of the CFTC is going to be. I know that if either of the sitting Democratic commissioners are made the chair, that they will be terrific. They've opposed all of these actions by the Trump administration that I've criticized. I suspect that whoever is appointed the chair will follow in that vein. The fact that Gary Gensler will be working shoulder to shoulder, and he's already calling into question the use of these total return swaps, will be very helpful to the CFTC. And by the way, as you mentioned, I worked with Brooksley Bourne back in 98, 99. We made the very dramatic step of trying to regulate swaps in that era, which has been documented in documentaries, American Casino, The Warning, which is a 1-hour PBS documentary about Brooksley's attempt to regulate swaps, and a lot of writing about it. I have every confidence that thoughtful, progressive regulators of either party will take this challenge on, and it will be among the first things they will want to do.
Excellent, excellent. I want people to start firing questions into the Q&A box, and I will get to as many of them as possible. So here's one from Thorvald Grungmo, and it's about collateral. I'm not going to read the whole question, but you said banks have retreated as market makers because of stricter regulation. So we're left with the financial markets more fragile. Part of the problem might be the fragmented regulatory system, but could it also be that this collateralized approach is wrong? Perhaps we need to scale down the runnable liabilities by stricter regulation of repo lending by banks to the non-bank sector. Anybody want to grab that one?
Well, I'll jump in and say that there's a raging war between progressive financial regulatory scholars and and others who are centrist about what to do about that issue. And the most aggressive proposal is to institute a Glass-Steagall 2.0, which would locate all substitutes for money within the regulated banking system and essentially prevent shadow banks, non-banks, from funding themselves with short-term repo or similar funding.
And do you think that's a good idea?
You know, I have to say I have moved closer to that position over the 2008 financial crisis and then our near miss of a financial crisis last year. However, I do worry about what we saw in the 1970s, which was very effective regulatory arbitrage by the securities industry that did, to some extent, undermine the solvency of major banks. And I don't think we've given enough credence to that concern. And so then the fallback position would be, do we allow non-banks to continue to fund themselves with these instruments, but regulate the leverage ratios and haircuts, margins much more heavily?
Okay, good. And the same questioner, Thorvald Grungmo, has a question for Professor Judge. And I didn't know about, so I'm just going to read the question. You have written about the need for credit policy guidance from the Fed. Do you see the need for such guidance outside crisis lending under 13.3? E.g., could the Fed take more of a guidance role in credit generally? And he refers to a proposal by some of your colleagues for sort of a developmental finance role for the Fed.
Yeah, so this is another issue like the one that Pat was just discussing that's being hotly debated right now. Right now, in terms of the Fed itself, I'm not yet at the position where I think it's in the optimal position to do this. I think it already has a very, very full plate. And I'm more flexible than many of the traditional folks that I'm around in the central bank domain in terms of understanding that the mission and the function really have to evolve as the economy evolves and the challenges that we're facing evolve. And so I do think that there has to be play in the joints and room for growth and evolution in terms of actually playing a more active role directing capital. I'm personally not yet there, but I think it's a conversation to be had. I mean, I think part of what we're seeing right now is a bunch of conversations that we're starting and trying to figure out what's at stake and experimenting. And so I just also want to clarify on this. It's very often worthwhile to disaggregate what's the policy aim that we want to achieve, or kind of how do we want to go about achieving it? And then institutionally, who do we want to have taking the lead in that effort? And despite what I just said about the regional Fed banks, which I fully believe, the Fed does remain significantly more insulated. And I think when you're talking about not just engaging in monetary policy and massive role in financial regulation and lender of last resort, but going on to really allocate capital, I generally would want people who have slightly more accountability and more direct modes of accountability to elected officials to play more of a role. I do think in times of emergency, it's a close line between credit policy and lender of last resort. And so that's what I've written about. And I think the Fed potentially could play more of an important role there. We need to pull it out further. But
okay, well, that's a great question, a great answer. Here's one from Prabin Basial. There seems to be heavy focus on capital adequacy, but we've seen that liquidity stress is less predictable and more damaging. So even after bringing under the jurisdiction of regulators, do we have proper models to predict stress? And I would just add to that question, specifically, do we have proper models for ensuring avoiding liquidity crises? And that's for anybody who wants to grab it.
Well,
go ahead.
I would just take a piece of that. Part of the liquidity crisis comes from these margin calls that can't be covered. And in fact, in 2008, 2009, were it not for the federal support of the banking system, there would have been massive failures on margin calls from hundreds of trillions of dollars of swaps worldwide. Money was put into the market, and therefore the defaults did not occur. I think that one part of the liquidity crisis is if some of it is coming, and every article you read about GameStop, Arcados, et cetera, talks about these total return swaps, which are a way, in the best of circumstances, to get benefits from equities without owning equities. And the margin calls for Arcados came very late in the game when they were running out of money or were in financial straits. If you have clearing of these swaps, the clearing facilities, twice a day, if you lose $1, you've got to make that dollar up. If AIG had had its negative credit default swaps cleared, they would have in 2 or 3 days realized that they were heading for a disaster. So I think a lot of the liquidity crisis is the inability to cover margins, and the inability to cover margins comes from a very lax scheme of requiring swaps counterparties to pay margin.
Great. Jan Kregel sent me a chat message with a couple of paragraphs from a news story. I think it's in this morning's Financial Times. And it says that Gary Gensler, in testimony released ahead of his appearance today before the House Financial Services Committee, expressed concern about the prominent role of Citadel Securities and other big trading firms, the role they're playing in equity markets, warning that, quote, healthy competition could be at risk. And he's directed his staff to look at whether policies are needed to deal with the small number of market makers that are taking a growing share of retail trading volume. Is that something that any of the three of you have any thoughts about?
Well, let me just take a crack at that. I mean, what Gary is talking about is that through the pay for order flow concept, which is he is asking to be studied, these entities, such as the one he mentioned, are paying to get people to trade stocks through their dealership. Now, where do they get the money to pay that? They get it through borrowing, and some of it comes from engaging in swaps contracts where they, through their swap counterparty, they are given money that allows them to pay for order flow. They have so dominated the pay for order flow concept with the money they have borrowed that they've edged out other market makers. And what Gary is talking about is a lack of competition in the market making thing. I think the hedge fund he mentioned, Citadel, has 47% of the market making in certain of these markets. And if they didn't have these swaps giving them the money to pay for the order flow or other borrowing that they're doing, if that was regulated in a more comprehensive fashion, they would not be able to dominate the market, which Gary sees as a hindrance to people who are involved in the purchase of equities.
Very good. Anybody else have anything on that? If not, I want to ask Professor Judge a question, which is, this is, of course, the Hyman Minsky conference. And I asked you ahead of time if you had anything you wanted to say to bringing in Minsky. Professor Greenberger did talk about the financial instability hypothesis a few minutes ago. But Professor Judge, in your work, where do you think we are, for example, in the various stages of finance? And go back to my niece who wants to put her $200 into into Dogecoin.
Yeah, there's a lot there. So I mean, this is not my particular area of expertise, but of course I will happily jump in a little bit. I mean, I think part of what's interesting with the Minsky frame is you almost never know precisely where you are while you're in the midst of it. So one precautionary note that I would put out there is I think part of creating the optimal level of resilience is some humility about knowing when we are going to be right at that precipice and taking steps to build in some of the stability that we need and the mechanisms that we need to deal with it if we are further along than we think. I mean, I think a lot of people look across a whole variety of asset classes right now, from housing to equities to the incredibly low spreads on, really not very well rated bonds. And then you have asset classes like NFTs and all of these various cryptos. And it just feels like, okay, there's something crazy going on here. On the other hand, we are in a period where there's been a meaningful economic shift. And what had been an incredible shock that created massive dislocation and that has still created meaningful dislocation has also really changed government policy and helped promote certain types of private innovation. And I don't know if we understand what growth is going to look like as we continue to come out of this. So I'm humble about where we are with respect to kind of where on that curve. But I think part of his other contributions were just, we always have to be mindful of stability or instability and the threat of instability. Periods of peace are what sow the changes in behavior that lead to the subsequent fragility. And so that's why we need the ongoing diligence and why I have the concerns that we do. And yeah, that we really need to be mindful of debt. And so this goes back to some of the other comments, but I think as we're seeing these bubbles grow, or what might be bubbles potentially grow, trying to figure out how much of it is debt financed is oftentimes going to be key to understanding, can you unwind smoothly, or are you only going to unwind in a way that has massive and destructive ripple effects?
Yeah. This is an interesting semi-finance question from an anonymous attendee. What are your thoughts about the implicit leverage in the supply chain, referring to Zoltan Posar, who said during the COVID crisis that the supply chain is the payment chain in reverse, and an abrupt halt in production can quickly lead to missed payments elsewhere, that this contributed to the contagion in March. It's a little bit an offbeat question. I don't know if anybody has any thoughts about it. Supply chain being, of course, integral to finance. Supply, that's how they make their payments, by finance.
Actually, I'll jump in two different ways that don't respond directly, but hopefully build and productive. First of all, I think Posar is incredibly insightful on all these issues, so I'm never going to disagree with him. But second, and it actually goes back to the question you had about Citadel and the increasing role of Citadel. I mean, I think that there is a refreshing effort to think more about market structure. I think for a while, there's been incredible passivity when it comes to market structure, no matter what the domain is, with the idea that there's going to be kind of a Schumpeterian mechanism through which everything works itself out, and if people get too big, they're also going to get lazy and inefficient, and we're going to have a technology that blows them out of the water. I think what we're seeing in intermediation in finance, but also outside of finance with Amazon and Walmart, is middlemen tend to aggregate a certain set of skills and resources and relationships that they then leverage to shape subsequent lawmaking and to shape the market structure, to buy up competitors, to edge out potential innovations and change in ways that we ought to be mindful of. So I don't want to prejudge the Citadel issue, but I think we need to think about that intermediation. And I think the corresponding extension of that does actually have to do with the complexities of the chains through which both goods are moving and through which finance is moving. And so 2008, you can think about it as kind of a capital supply chain where with these layered securitization vehicles, asset-backed commercial paper, money market mutual funds, and the like. Now what we're seeing is in the real economy, companies were overly optimistic about kind of the ability to constantly source what they need to, even as they increasingly outsource. And even as supply chains, we no longer had making. It was this disaggregated process that was very long and complex. And I think scale played a role in both these domains. And I think in both those domains, there's a lot of fragilities that you then really need to pay attention to that are too frequently underestimated, in part because they create externalities.
Sure, yeah. Professor McCoy, I told you also that I might throw a Hyman Minsky question at you.
Absolutely.
And can you talk about how your work intersects with Minsky's work?
Sure. So I think it's fair to say that in the past 20 years, I've gotten a reputation as a contrarian, and sometimes a Cassandra, raising concerns during very vibrant markets, raising financial stability concerns. And there certainly was a period around 2002, 2003 when I really felt like I was on the outside throwing pebbles at the window about the subprime market. And so Minsky's learnings are very, very important to me for that reason, that to echo exactly what Kate said, it's during times of a vibrant economy that we really have to be mindful of potential financial stability threats. And of course, that's the time when we're most likely to have amnesia.
Sure.
Now, that said, I will say that the current period of 2020/2021 is very confusing because we had in March of 2020 what I would call a near miss of a financial crisis. And unfortunately, it took vast intervention that then has compounded moral hazard in the system.
Yeah.
But roll around to the last quarter of 2020 and then this year, where we may have a stock market bubble. We're seeing bubble behavior, as you point out, and it all seems quite incongruous with an economy that in other ways has significant points of weakness, and again, this near miss a year ago. So I think that this particular period is difficult to parse in terms of what bubbles are real, what may materialize, what is unlikely to materialize.
Very good. I could squeeze in one short question. It's the last question in the queue, and it's to Professor Greenberger. And I don't understand the question, but I hope you do. It says, to what extent are the four major swap dealers informally following guidance that they're formally avoiding? Does that ring something to you?
Well, let me try and do my best with that. I think what I would say is that the four major swap dealers were the architects of getting about half of US swaps negotiated, arranged in the United States, be exempt from Dodd-Frank's transparency requirements by getting them off to their newly de-guaranteed foreign subsidiaries. So they did that informally. It took the CFTC a year to figure out what was going on. They are following that informal guidance. If what you mean is that are they informally following Dodd-Frank rather than doing it by formal requirement, the answer is no.
Okay.
They are not using the clearing facilities that were set up by Dodd-Frank. I think their counterparties have questionable capital adequacy and have an inability to post collateral when they are so rarely asked to do so, and only asked to do so in a crisis. When things go well, in the Minsky terminology, everything seems fine, but the relaxation of good times brings around recklessness that falls apart when margin has to be paid and cannot be paid.
Right. All right. Well, we are right up on our time, 12:30. So I want to thank all three of our wonderful panelists for a great session, and I'll turn it back over to Dimitri.
I too want to thank you all for a terrific, I think, session, which means that we will ask you to join us again next year when there will be at least 1 year in the Biden administration and also Janet Yellen to see what progress we have made. So thank you again very, very much.
Thank you.
Thank you.
Thank you.